Okay guys, so this is the second video in the series of 3 working towards this SAC on Friday the 24th of July. Still staying with the first outcome, but this time we're moving into Key Knowledge 3, which as per the study design is an overview of lawmaking through the courts. Okay, now we know now, or by now, that the main function of the courts is to settle disputes, but the other function of the courts is that judges also play a really important part in the making of new law or changing existing laws. Now, the way in which judges create new laws or change existing ones is different to the way in which law is created or changed in Parliament. Now, you looked at that earlier in the year with Swanee. Now, judges don't actually set out to create laws, but just by part of the process, the decisions that they make when resolving cases, new laws can actually result from those decisions. Now, when this happens, this type of lawmaking, there's 3 different names for it, given there, those 3 things in the yellow. Usually it's referred to as case law or common law, but if you see either of those 3 things, we're all talking about the same thing. Basically, case law, judge-made law, and common law is the making of law by judges in the process of resolving disputes in court. Now, all of this happens through what's called the doctrine of precedent. This term precedent is really important to have your head around. And look, it really means the same thing that it means in the normal sense of the word in life. You know, it's not a different definition just because it's legal. But in terms of legal, it is a legal principle developed by the courts. They're found in the recorded decisions of judges, and these are collected over time, like every case that goes up to court is recorded and kept. And then what happens is other judges, when they hear similar cases in the future, they refer back to those previous decisions that have been recorded when making their judgments about the case before them at that time. Then this reference acts as a guide in determining how the law should be applied to the current case. So really it's all about looking how this kind of situation has been dealt with in the past and make sure that we're dealing with it in the same way right now. One way to sort of demonstrate this is to look at this example here. So take a minute, pause your video and read that situation. And this demonstrates how precedent works. The idea that similar situations should be dealt with in similar ways. In terms of the law, similar cases should be decided in a similar way. And this concept is at the centre of our idea of justice, basically. If people are to be treated equally before the law, legal principles or past decisions must be followed and applied to later cases involving similar facts. So hopefully that kind of all makes some sense. Just to help here, there's a little video which is also available in the Common Drive. A little video I picked up, Professor Bertie Binkham, who's a little professor from Northern England, explained the doctrine of precedent. I think it's a 6 or 7 minute video. I'd go back and watch that one as well. It explains it in really kind of simple language, and if you watch that and do the rest of this stuff, you'll really kind of get this idea of precedent into your head. So have a look at that video too. Now, the practice of precedent goes back to way before parliaments were even formed and we even had legislation. Now, a lot of areas of law, as you will have looked at earlier in the year, are covered by legislation, but a lot of the law that we still use today is actually covered by case law and by this idea of precedent. Now, one important note to make is that not every decision made by a judge contributes to this case law. If it is going to happen though, the judge's statement must contain one of those 2 things in the yellow there at the bottom of the screen you're seeing now. So if we are going to get case law from a judgment, we must have one of those 2 things present in the judge's statement when they're summing up the case. Now let's have a little look at precedent kind of in action. Now, the Australian Legal Information Institute holds a massive database on all the cases that have been through the Australian courts, including information on which precedents will follow within each case. So kind of to demonstrate how this actually works practically, just going to take you through some steps that I want you to follow. So open up an internet browser alongside the screen here. Get into Google and just put into the Google search engine AUSTLII, as in step 1 there, AUSTLI, for Australian Legal Information Institute. Now the first hit it gives you takes you to the website, so click on that link. And what we'll do here is use the Adrian Bailey case from a couple of years ago, the guy that killed Jill Maher, just to kind of demonstrate this is a case that I'm assuming everyone's kind of familiar with, at least to some extent. So in that search box at the top of the page, type Adrian Bailey as it's spelt there, and you should now see a list of cases crop up. Roughly 500. When I did it, it was 470, 480, something like that, but that can change. Then look for the case titled The Queen versus Bailey, the Queen v Bailey 2013, and the date given was the 19th of June 2013. Now when I did this was number 7 on the list. And when you're on that case, click on it. Now when you get in there, you see quite a lot of information. It's basically the judge's statement and summing up of the case. It gives a lot of information. Now near the beginning, it also gives all the cases that the judge referred to and used as precedent in making his decisions on this case. And as you read through the information, which is really interesting to do because there's a lot of information about that case in there, a lot of detail. Some of it makes for quite hard reading. It really gets into the nitty-gritty. This is not stuff that was reported in the press, but throughout, and particularly towards the end, you can see where the judge has actually referred to other cases to kind of explain the decisions it is making kind of along the way. So this is precedent in action. Now, the doctrine of precedent, I used that term earlier, is very simply just a set of rules that guide judges in making and applying precedents. Now, the decisions of courts are recorded in law reports, and that's kind of like what you just looked at if you looked at that Adrian Bailey one online. And law reports record the judgment in a case, and again, that's what you just looked at, the judgment in the case of Adrian Bailey versus the Queen. And when I say the Queen, that just means the state. Now, the judgment in a case is a formal statement by the judge outlining these points here. I'm not going to read them out for you. You can see that. Some terms that you need to be familiar with and will be able to explain, and some of these actually were explained in the video, so you might have notes on these already, but we'll just kind of go over them to make sure we've not missed anything. Stare decisis in Latin, and Latin is used a lot in law, historical terms, to stand by what has been decided. So this is the principle of precedent here, basically. So what that's saying is, or what that rule means, is that lower courts must follow the decision of higher courts in similar cases. So remember back when we looked at reasons we have a court hierarchy in Unit 1.2 earlier in the year, sort of not soon after I took over from Swanee. One of the reasons was precedent, and this is where that fits in. So lower courts follow the decisions made or the precedents made by higher courts. And there's a term in there in the blue, ratio decidendi, which I will explain in just a second. Basically, this makes sure that law is applied consistently throughout the land, or throughout the state in our case. And again, that's a cornerstone of our legal system, that the law is applied consistently as far as possible. So stare decisis, to stand by what has been decided. Now ratio decidendi, which was in there, Latin for the reason for the decision. Now this is the most important part of the judgment that the judge makes when summing up a case. It's the reason the judge is giving for why they have made their decision, basically. Now, other judges then refer to those reasons when making judgments about cases that come before them in the future. So when a judge has a case before them, they would look at past cases which were very similar, and then they will use the ratio decidendi, the reasons the judge gives for making their decision to make the decision in the current case, if that makes some sense. Ratio decidendi. Obiter dictum, by the way, in Latin. Now these are statements are made by a judge when there's something up the case that are not actually part of the decision and don't affect the outcome as such, but they are referred to kind of by the way, in kind of in a matter of passing. Sometimes these comments, or they're referred to being made as a comment made in obiter. They don't actually form part of binding precedent, another term which we will define in just a second, but they can be used by a judge in a later case as persuasive precedent. So it's really important to understand what we mean by binding precedent and persuasive precedent, and that's what we look at now. Binding precedent is a precedent that must be followed by lower courts in similar cases. Note lower courts in the same court hierarchy, so in other words for us in Victoria. Now not all precedents are binding on future cases. In order to be binding, there's a couple of things that must be true, and those are set out there for you in blue. Very important to remember. So the County Court of Victoria must follow precedents in the Supreme Court, but the County Court of Victoria doesn't have to follow precedents in other states. You just refer to the court hierarchy. We look to see how the precedent system works, basically. Now, persuasive precedent. This is different. Now, when decisions from other court systems, so in our case, other states, New South Wales, Queensland, WA, whatever, or overseas even, are referred to by Victorian judges. So sometimes judges in Victoria, when they're making a decision, they will actually refer to cases from other states or even overseas. Now this happens mainly when it's a new type of case which has not previously been heard within the Victorian system. So in other words, it's being heard in Victoria for the first time. Now in this case, because it's never been heard before, there is no binding precedent. No binding precedent exists because, this is a new type of case. So what happens is judges can go outside of our system into these other states or overseas systems for guidance in how to deal with the situation before them. Now they would go to court hierarchies where this type of case has been heard already, and then look at the decisions the judges made in those cases. Now the difference is this is not binding precedent, these become persuasive precedent because our judges are not bound to follow. In other words, they don't have to follow. So persuasive precedent means basically decisions made in other court systems which can influence our judges and they can refer to them, but they don't have to follow them because they're not within our court hierarchy. Obiter dictum comments, the comments by the way, can also form part of persuasive precedent as well. Now this part is very, very important here. There's a couple of cases. Donahue versus Stevenson and Grant v Australian Knitting Mills. This is really, really important. These are two of the most famous civil cases actually in the area of negligence, which we look at more detail in Key Knowledge 4, the next video, in Australian law. They're two cases central to the development of negligence law in Australia, and you need to include these in your notes, the details of these cases, so that you can refer back to them in the SAC, and also make sure that you understand and can explain how they're relevant to this idea of persuasive precedent. Now details are on page 243 of the textbook. Make some really good notes and include this stuff in the notes you take into the SAC. Persuasive precedent comes in here because basically Donahue and Stevenson was an English case which happened before when Grant and Australian Mills came to court. We hadn't had a case like that in Australia before, so they actually used the persuasive precedent of Donahue and Stevenson in England to make a judgment So that kind of became persuasive precedent. We didn't have to follow it, but they did follow it. Persuasive precedent, and then all cases similar since in Australia have followed that one. Really important case. Make sure you get good notes on that one. All right. So we've said that judges are usually bound by precedent, previous decisions set in a higher court, but judges must also not be too restricted in how they apply the law to cases before them. Therefore, judges are able to change precedent as well. And this is how they can do it. Now, the extent to which a judge can change an existing precedent depends on those two things in yellow there. And there are 4 processes that we're now going to look at. Those things down the bottom in orange on this screen right there. So we'll look at each of those in turn. So changing precedent the first way, called distinguishing. So this is where a judge decides that the precedent doesn't actually apply to the case before them. If the judge thinks that the facts in his case are not the same as in that previous case, they will then distinguish the facts, i.e. say that they're different, and that means he can come up with a different decision and not follow the precedent. That also means that the original legal reasoning or the original precedent isn't changed, because that would still apply. All this judge here is saying is that the facts in my case are different, therefore I don't need to follow that precedent. So the precedent can either not applied in this case, or if it's kind of very similar, you might add to the precedent, add a caveat or add a if this happens, so and so. Now, if the court is a superior court, the judge may have created a new precedent through the process of distinguishing. So that's how distinguishing works. The next one is disapproving. Now, we know that a precedent set in the superior court in the same court system is binding upon lower courts. By now we all know that. But that doesn't mean that a judge who isn't happy with that precedent or disagrees with it, there's nothing they can do about it. There's not a lot they can do about it, but there is something. So that judge can make comments forming part of the obiter dictum, indicating that they do not believe that particular law is appropriate. And this is called disapproving. So they're disapproving of the law as it exists or as it stands today. Now, they still have to follow the precedent which exists in the case they are, in cases before them, but in the process, by including disapproving comments in their judgment, they've sent a clear message to the High Court that the judge believes the law should be changed. Now, this could, particularly if a few judges do this actually might make the judges in the High Courts actually look at a piece of law, a piece of precedent, and actually make those changes. And the world changes, technology and so on and so forth, so law does need to change. So sometimes this is the reason which kind of gives the reason for these sort of changes, because the law no longer is relevant or appropriate. The third way precedent can be changed is simply by overruling. Judge in a higher court can overrule an earlier precedent and replace it with a different one. So it's all about seniority in a court hierarchy. If a precedent is overruled, that original precedent is no longer binding. Very simple one. And finally, reversing. Now this is all about appeals. So we know that if one of the parties is not happy with the outcome of a case, they can appeal to a higher court. That higher court will then look at the reasons given for the original decision, and if that higher court disagrees with those legal principles, the higher court will reverse the decision. That means the precedent set by the lower court can no longer be applied. So they're the 4 ways in which precedents could be changed by judges. Now, at the beginning of the year, you looked a bit at how laws are made using legislation. We've now said that laws are also formed by judges through precedents. So a question we have is, how do the two work together? And it's a little bit like this. Basically, an Act of Parliament that you would have looked at earlier in the year sets out in broad terms the rights and responsibilities of individuals. Now, when hearing a case, a judge applies these broad definitions to specific circumstances. Now, to do that, they have to interpret the words used in the Act. Often, Act of Parliament are very, very wordy and not all that easy to understand. So judges need to use their expertise to actually interpret what these acts of parliament means. When they do this, they give reasons for their interpretations. So they explain why they have interpreted the words in the way that they have. These reasons form a precedent. In future cases where the meaning of the words of an act are questioned, judges then refer back to those original precedents, or where the judge originally was deciding what those words mean, to then decide for them what the words in the act mean. So when judges interpret the meaning of words in acts, the reasons given for those interpretations can become precedents. Now look, that's the theory for this part, but there's a really, really important part I need to tell you about here. And this is really important for the SAC. So at this stage, what you want to do is look back through your notes and drawing from what you've already got, and probably going into the textbook in the relevant pages a bit, make notes on the following 3 points. Number 1, the reasons why courts need to make laws. Number 2, the ways in which courts can make laws. And number 3, the limitations on the ability of courts to make laws. Now, if you have some good thorough notes on these 3 things that I just said there, it's going to help out in the SAC. And the stuff that I've just covered there, plus maybe a bit of textbook work, rearranging the stuff that I've just given you there in this video, should allow you to make some decent notes on those 3 things. Really important that, again, you bring those notes to the SAC with you, otherwise you will be disadvantaged. And that is the end of video 2, and we'll see you in video 3 next.